You've heard my opponent's commercials, obviously. Let's go back to the first question. First of all, I'm going to ask the last question first. I have handled thousands and thousands of civil cases. I have a reputation for being very knowledgeable, but more importantly, I read everything that comes before me. The attorneys, when they come to my courtroom, know that the hours they spent on that brief, putting it together, was not wasted. I read those briefs. Sometimes I know the case better than they know. I've researched it enough. So the answer to the question reference civil, there's no question. You ask the attorneys in this area, if you said, where would you like to put Judge Clark? You put in criminal or civil, they'd say civil. I am one of the judges that they look forward to coming before. Like one of them said, he said, Judge, I haven't won many times in front of you, but I know when I leave out that I can see where you're coming from. You know. So the answer to that question is mostly yes, definitely yes. Especially when you look at the thousands of civil cases I handle. You know, as a judge, I have handled as many civil cases as probably 10 lawyers would handle in private practice in their career. Because they come in with one case and then they go out. I'm handling case after case after case after case. I'm preparing for case after case. So I see all type of law. They may handle only a certain type of civil case. They may have never handled a child custody case. Those are some of our most important ones. On a daily basis, I'm making those tough decisions that lawyers don't. If you think about it, that's the difference between a lawyer that practices and a judge. A judge has to make those tough decisions. A lawyer is hired, and so he looks at it from one-dimensional. How can I get the evidence together and interpret the law, the cases and the laws that will win on my client's proposition? Not how can I be objective, how can I be fair, how can I win for my client. Judge doesn't have that luxury. Our job is multidimensional. We have to look at all the law, we have to interpret it properly, and we have to make decisions as to credibility. We don't have the luxury of being one-sided. We have to be fair, objective, but more importantly, totally independent. And that's the kind of judge you want. And that's why, as I visit all these parishes, one of the things I keep noticing that they say is, we want someone on the bench who has been a judge before, that has made those tough decisions, and has a track record that we can look at. And I think that's an issue that my opponent is losing the debate on, because the public knows what they want. Now let me tell you, when I first became a judge, during my first term in office, I made a mistake. I got in there and I worked hard and kept working. The problem is we had no type of case management system, and when you're working that many hours, cases fall through the crack. You know, if you look at it and you say, 5 years, well, it's sort of like that dollar bill that fell out of your pocket. If you didn't know you lost it, you don't go looking for it. When it came to my attention that a case had fallen through the crack and I didn't realize it, I answered it and then started looking for more. And when we found these cases, we reported them to the Supreme Court. I resolved them. I sent out a letter of apology to each person and made a decision that I was going to make sure that this inadequacy in our system was cured so that it wouldn't happen to me or another judge again. This campaign is not about one issue that occurred in the early part of my career, because I'm confident that my career, 3 terms of being a judge, that all the things that I've done greatly overshadows that one incident. Did it embarrass me? Yes, it did, because I have a great work ethic. It was hard to swallow. But that's not the key issue here. The key issue is experience. My opponent has made that a key issue because it's the only string he has to run on. You've been around in politics long enough that if you don't have anything to say about yourself, then you've got to attack, attack, attack. The people that came out and supported me and asked me to run, whether they be lawyers, judges, sheriffs, DAs, they knew about that. They knew my career, though, and knew all the good things I've done through my careers, and they knew what the other judges and lawyers thought of me. And that's why they got behind me. Sheriff's Association didn't put their reputation on the line without knowing that. Well, it's not a good thing to be sanctioned, but it is a good thing. And like I said at the beginning, if you'll look at the transcripts, I went in and admitted to everything. The only thing I said was the disorganization was because I was working too hard and had too many cases. They disagreed with me on that. But then later, after all this was over with, and I put together a package and went down to the Supreme Court, they sent a site team in and found that we were grossly in need of more judges. Not one judge. We needed more. They gave us 2 and said, come back and you'll get another one later. There's no bridges to build. I went there and admitted to everything. They did their job. I accepted it and came back and did what I thought was the best thing to do, try to be a better judge and implement programs that I thought would make our court one of the best ones in the state. And I think that's been very successful. I don't think anyone would disagree with that. In fact, if you look at it, these are the same justices that organized a uniform rules committee, which is, I don't know if you know what that is. In the old days, up until recently, the attorneys would come from New Orleans and come to Lake Charles or Monroe. Well, you'd have to know what the local rules were. And if you didn't, your client may lose because you didn't follow the right paperwork in that particular parish or that particular district. That's not right. And the Supreme Court was correct in saying we need to put together uniform rules. So whether you're practicing in Baton Rouge, Monroe, or Lake Charles, the rules are the same. They appointed me to that committee. And I've been on that committee for several years now. And it's been a major, major accomplishment. We're still changing some of the rules. But right now, there are uniform rules for the district courts. So if you come from New Orleans, or if one of our attorneys goes down to New Orleans, the rules are the same. So we have a good working relationship together, and I'm very proud of the Supreme Court that we have. No law journals. I've co-authored the drug asset forfeiture law, which I think was major. As far as writing opinions, and in fact on that, I decided that the Constitution would have found the law unconstitutional. So we had to change the Constitution at the same time we wrote the drug asset forfeiture law. But you know, a Supreme Court justice does what a district court justice does as far as writing opinions. The only difference is their burden is different. There they look to see, did the judge make any errors? And 2, is deferring to the court. Is the judge correct without reevaluating credibility? Because the district judge makes credibility calls as to the veracity of witnesses. After that, the Supreme Court or the Court of Appeals looks at it and decides strictly, 1, was the right law applied in the right manner, and 2, interpreting it most reasonably for the judge as far as credibility, was the judge correct? And most of the time what that you see is they say, we find that the learned child judge was not in error. You know, that's something a district judge does, is prepare and read briefs. Supreme Court reads the trial transcripts, or they'll read a brief summary of the trial transcript.